This is our third hearing of the proposed creation of city rental registry. I would like to thank my colleagues who have joined me, as well as our departments of development and building and zoning for the work they have put in during this process. Additionally, I would like to thank Steve Dunbar from the city attorney's office, who is here with us as well, and for all the work that he has done behind the scenes to help get us to this point. Similarly to the last hearing, to date, our office has received several emails and calls sharing support, constructive criticism, and general comments about the registry. Based on the feedback from our residents and stakeholders, the Department of Development and Department of Building and Zoning made a third round of changes to the proposal, which they will present, followed by public testimony for this evening. Before I pass the mic over to Director Messer, again, I just want to thank all sides of folks that have engaged with this. I think this has been a very, I would say, transparent process and a sausage being made, if you will, in real time. And so I just want to thank everyone who has both come out in support, but then also those who have helped, I think, strengthen the proposal and where we are. Before I move to our administration to give us a presentation, any opening remarks from my colleagues? No? Okay, thank you. And thank you again to our housing chair for being here, Councilmember Ross. She's been in this space a long time. And so thank you again for your feedback and your leadership in our housing efforts. And now with that, I will turn the floor over to Director Scott Messer with our Department of Building and Zoning, as well as Deputy Director Hannah Jones with our Department of Development for the presentation for today. Director.
Thank you, council member, other members of council. I also would like to express my thanks and gratitude to all of you and your staffs, as well as the city attorney's office, folks in development, and a lot of the stakeholders for their input up to this point. So as you mentioned, we've made a few changes in this latest round, and I'm going to summarize a few of those and then take any questions that you all may have, or as we hear from the presentations and the speakers tonight, I'm happy to answer any questions along with my peers here from development. So the first thing that I want to highlight is, and I'm just going to go through a few items that are different now from previous proposals. When you look at the information that we're requiring as a part of the registry, we have made a few changes to that section, but nothing significant. Primarily, what we did is a few clarifications of the information that we need, and we added a category of information that's linked to what I'm going to describe in a couple of moments, which is a inspection component that has been added, a preventative education inspection. So in order to carry out that inspection that I'm going to talk about in a minute, we need some additional information from registrants. So we're going to be asking for things like what kind of shared mechanical systems they have, whether they might have a boiler system, identifying common areas, identifying interior egress, retention ponds, things that exist on their sites are going to help us in doing what I'm going to describe in a moment in terms of the inspection process. That's the major change that we made to information that we need from the registry. Another big change that we made was to the fees. So the fees that we're proposing right now are $15 per unit, down from $20 per unit prior to this, with a maximum of $1,500 per complex. So a complex with 100 units would max out on the fee and only have to pay the $1,500. We clarified that all fees collected as part of this registry can only be used for purposes connected to the registry. They would not be going into the general fund. So we made those clarifications. And then, as I mentioned before, we added what we're calling a preventative education inspection. If you recall, in our previous proposal, we talked about self-attestation, and that on an annual basis, folks who register would have to submit a document certifying that, to the best of their knowledge, there are no violations or outstanding code violations to their critical systems. We're still going to ask for that, But then once every 3 years, we're going to conduct what's called a preventative education inspection. This inspection is at no extra charge to the registrants. So not only have we lowered the fee to the $15 per unit, but we have also provided an added service that once every 3 years, we will go out and conduct an inspection. The purpose of that inspection is, as it's named, preventative and educational. So we will not be writing orders and issuing violations during that inspection. If there are critical problems that we identify, those will be referred to the appropriate department or agency to handle. But the purpose of the 3-year inspection is truly to provide education, feedback, and to try to come alongside the owner of the property to try to address any problems that we identify in that inspection. Finally, above and beyond those issues, we just made a couple of specific changes and clarifications, nothing significant. We are highlighting that we will be using civil action only to enforce this registration, so not criminal penalties will not be a part of this. It'll be through civil penalties and civil action through the court system. We also have committed to a full review and report of the program to City Council on a timetable to be determined. But rather than it be nebulous, we are making a formal commitment to review the entire registry and the rules and regs associated with it and fees within a specific timetable so that we can really look at how this is functioning. So those are basically the main changes that we made, and I'd be happy, or I'll turn it over to Development to see if you have anything additional.
Thank you, Director. The only thing that I would add is the Department of Development really sees the educational component of this as an area where our Division of Housing Stability can lean in. How do we come alongside BZS to help on the education component, both for the property owners and the tenants? So does this give an opportunity to engage proactively with them? Does it help us be able to communicate more effectively what the expectations are for a landlord, but also for a tenant, so that it does not become necessarily a punitive exercise, but one that's more proactive to help maintain good relationships between landlords, tenants, and the city?
And I would just also add, council members, that this 3-year inspection that we've added to the registration, it is not an automatic inspection of any interior units. So the inspection will be focused on critical systems, exterior areas, all the areas that I mentioned that we've added to information required from the registrant. The only way that we would be doing interior inspections is if there are violations that are referred out to the appropriate parties that already have a process to deal with actual unit inspections, or if the owner or the tenant requests us to do an inspection of an interior unit, we're willing to do that. But I just want to highlight that as a matter of course, that 3-year inspection does not include interior inspections automatically, but those could be a result indirectly from that inspection.
Thank you, Director, for that overview. I do want to kind of stick in that inspections piece of this. And really, I think, I think my first initial reaction and many folks would be that this doesn't have necessarily teeth to it, right? But I think that this idea of being proactive and going out is the thought process there that if there are glaring external issues, right, then that would then prompt or warrant code to come out or for us to investigate even further versus I think the more enormous task of going into every single unit. And then I'll have our city attorney chime in as well, kind of the legal hurdles around that other kind of more enforcement mechanism that folks would want to see. So you could just talk to more about that piece of it, being more proactive than necessarily what I think some have advocated for, even quite frankly myself, and how we landed there.
Yeah, thank you, Councilmember, for that. I would answer in two separate responses. The first is when it comes to the actual 3-year inspection that we've added, the preventive educational inspection, it's absolutely the case that that could result in interior inspections if we find something that gives us probable cause or gives us a reason to refer that. So, for example, if we were to do that inspection and we found that a shared heating system was not working properly, then we would refer that to code enforcement, and code enforcement would go through their normal channels of getting inspections of affected units and making sure it's working properly. If we found a fire code hazard, we would refer that to the fire division, and they could come out and follow up on that. So I want to be clear that we're not saying that if we find problems, we're just going to ignore those issues. What we're saying is those will be referred to their normal channels, and the process by which we would obtain permission to inspect interior units would be handled by those separate enforcement areas. So it could still happen. It's just not going to be us, randomly knocking on doors and going into people's property. Secondly, we didn't highlight that in my presentation because we've had it in our previous proposals, but we still have the conditional registration process, which gives us the authority to deem someone's registration as moving to conditional status. When that happens, and those happens for the sort of our more problem properties, areas that have had multiple code violations, and there's 4 or 5 triggers that would result in someone being put on conditional registration. That still does involve a component of getting into units to actually confirm that the units are in good condition. And so we still are doing inspections when triggered appropriately. And so the triggers are just a little different in that we would find some kind of violation in the general inspection that we do every 3 years, or if we move an owner to conditional status, that triggers interior inspections.
And Director, speak to, I think that's part of this update too, was there some clarification around the conditional status, and in particular, I think around violations and what we're looking for there, because I think that there was some consternation that folks think that we were going to go out and ding folks for things like high weeds or that kind of thing, right? I think the thought process for us and for me is, it is about holding folks accountable, absolutely, but it's also about compliance. Because again, we want our residents to be in safe living conditions, and we want to ensure that we have as many units still online, given our housing situation. So if you could just talk about the conditional registration, some clarification around those violations, the cure period, and some of the clarifications that we made in this updated proposal.
Yeah, so when it comes to conditional registration, as I mentioned, there's several triggers that would result in someone being put into a conditional registration status. So properties with 100 units up to, so less than 100 units, if they have 5 code orders, but code orders that are related to things like no heat, no water, no electric, means of egress, serious safety violations. So like you said, high weeds, trash, things that aren't related to critical safety systems would not be included, but they would have to have more than 5 of those in a 12-month period. For places with more than 100 units, they would have to have 10 of those within a 12-month period, and in both cases, those would have to be orders that weren't complied with within a 30-day period. So if someone complies with our orders within 30 days, they don't count, is what we're saying. If they are trivial or smaller orders that aren't related to critical safety systems, they don't count. So those triggers of how many code orders you've received in recent 12-month period, there's only a handful of those type of orders that are going to count, because either you've complied or they're not the type of orders that we're counting. We've done some math, we've done some review. If we look back historically at how many units are we talking about that historically would be in violation of those levels, it's less than 0.5%. So we're not talking about, dozens and dozens and dozens every month. We're talking about a handful of some of our worst of the worst, so to speak, that we would be dealing with on that, less than 0.5%. And then the other triggers are, if you've had vacate orders, if you're declared to be a public nuisance. So I guess what I'm, trying to communicate is that the properties that go into conditional status, I think there would be no surprises from folks as to who those properties might be, because the condition is going to be evidenced by these triggers.
Got you. Thank you for that. And just to, I think to that point, I think it's important to note this is not a gotcha exercise. I want to reemphasize that the vast majority of our housing providers who are landlords, who are small business owners, are doing the right thing. This is not about penalizing those folks, and it's not about us demonizing either housing providers, because the vast majority are doing the right thing and doing a noble thing by providing housing to our residents. Attorney Dunbar, if you could talk, the director alluded to this about probable cause. I watch Law and Order, but I am not a lawyer, nor do I play one. I defer to Councilmember Ross and President Pro Tem Dorrance for those types of things, as well as the city attorney's office. Could you just talk about broadly, I think, some of the legal complexities?
Sure.
What has taken us a long time to get here, I think, is around the legal complexities of how we have structured this, particularly around entering folks' units and the inspection piece. But if you could just talk about some of the legal challenges that we have had to really overcome to get to this point, I think that would help to level set with the inspections piece in particular.
Yes, sir. Thank you, Councilman. And I will tell you the short version is you cannot pass a registry that requires interior inspections of everyone's home, hard stop. Now, the longer version, if you live in a place, you got a right to keep the government out of it generally. And the ways that the government can get into your home, and a home could be a rental apartment, it could be your owner-occupied home, makes no difference for purposes of this legal analysis. There's three ways. A, consent. You can say, cool, come in, cop, firefighter, whomever. The second one is if there's an imminent emergency happening, if someone is chasing someone in, or if we see imminent threat of collapse or something. Third one is a judicial order of some sort, a warrant. And now the overwhelming majority of warrants happen when police are investigating a crime and they've got to say, I have specific probable cause to believe there's evidence of a crime on the other side of that door. That's what you saw on Law and Order, Councilman. Now the other type of warrant that is much less frequently used, but is what we're talking about here today, is an administrative search warrant. It is obtained from a court, just like a criminal search warrant is. The standard is not the same, and I will tell you this is it is a kind of an area of law where there are not clear statutes that divide it A, B, C, D. So what we as lawyers have to do is look at cases for how different courts have looked at similar laws and done that. I will tell you it is a hotly contested issue. There is currently pending in front of the Ohio Supreme Court a Canton ordinance where this was challenged. So all of that being said, you get my best shot at it, which is you can't say rental registry, government gets to go into everyone's unit regardless of what you want to hard stop. What you can do is create a regulatory scheme where you are basing those searches on a rational basis. And I don't mean that specifically for rationally, why does that person want to get behind that door? It means if you all are rational in how you are passing this piece of legislation. So it's not just if you've got an odd numbered rental unit, we can inspect you. It is things like, well, we have a history of code violations. We have the types of things that show us a more concerning thing. You still got to go get the administrative search warrant at that point. So again, if you don't have consent, if you don't have the emergency. So just high level, people think of it as you got a right to keep the cops out or other law enforcement. Roughly same rules apply to Director Messer's crew. But the most important thing we're talking about here today is in the administrative search warrant world, This entire process we are going through now, really good chance this whole thing gets challenged in a court of law. Our defense is going to be, we didn't blindly say, let's inspect whatever ones we want to. What we are going to say is we put a tremendous amount of time into determining what are our most concerning units, what is the process for us to inspect those units. I will tell you that I and my colleagues have done a review, had many conversations with Director Messer, Deputy Director Jones and her folks, and we feel what we've got in front of you satisfies those standards.
Thank you for that. And I'm sure there'll be more legal questions that I won't be able to answer, so thank you for being here. Director, could you just give us I think, an update on where we are as far as legislative language to date? So folks I know a lot of folks in this room have been following this closely. It's not been centered around legislation, but more or less a proposal, because we really wanted to workshop this with the community before actually having legislative language. And I'm going to ask you, want to give us an update on where we are as far as actually writing that legislation, it being introduced to council, but then want to go into, if you could have this distinction. I think some of the testimony we'll hear tonight, as well as what we've heard, are around kind of scenarios and idiosyncrasies that won't be captured in legislation, but there's a whole nother process around rules and how this implementation will work. So if you could just touch both of those for me.
Yeah, so essentially the proposal that we've been distributing to folks and that everyone's been reacting, in large part, that proposal then gets changed into actual code updates, code language. We have completed our proposed code language, and so that is going to be available for folks to start to review, to compare to the actual policy document that we've handed around. So the code language, we do have a draft of that, and we'll be able, after this hearing, to get that to folks so that they can review the actual code. And then you are correct, part of that code language talks about how some things are not necessarily spelled out in the code itself, but refer to rules and regs that the director may be able to implement as a result of the legislation and the code changes. And so, for example, some of the information we might ask for, the code would say something like, here are 5 things you have to give, and then other information deemed necessary by the department that would be spelled out in the rules and regs and might be updated from time to time. So if we decide that as a city we want to collect certain types of information, we can always just add that to the registry, as opposed to go back and change the code. So there'll be certain things that we'll be able to update or change that are rules and regulations, and then certain things will be codified in the code itself. And after this hearing, we'll be moving forward to adopt, first and foremost, the code changes and then the rules and regs that go along with that.
Thank you for that, Director. And I do want to be clear. I know I've said this on the record, and we'll say it again, that included in that legislation that I know I will move to ensure that there's a review period, just similar to our CRA policy, similar to our minimum wage policy when it comes to incentives, just to ensure that we are, one, holding ourselves accountable, but also ensuring that we're going back to make sure that as the city evolves and changes, so does our policies. And so I just wanted to make sure I had that clarifying note. Any questions from my colleagues for the administration or directors before we move to public testimony? Chair Ross?
Yep, I just have a couple of questions, a few questions, Director. I'll start with the rules and regs, since we're talking about it now. Rules and regulations would be passed in addition to the piece of legislation. Are those rules and regulations legally binding?
So the rules and regulations are, when you say legally binding, they will be referred to as in the legislation itself. And so they're legally binding in the sense that the legislation incorporates or gives me, as the director, the authority to implement those, but they aren't code language. So they're changeable, they're different than the actual code language. So that's the best I can say.
And so when you decide as director that it's necessary to change rules and regulations associated with a piece of legislation, is there a notice period? Are you letting the public know? Are you letting stakeholders know that there are changes in these rules and regulations? And if so, what is that process?
So I don't know the exact process. I don't know if Mr. Dunbar has any information on that. Probably not. So I would just say the answer is that typically we do provide plenty of notice of rules and regulations changes, and we do publish those. But if you're asking me what's legally required, I'm not sure.
I'm just asking what your process is.
Yeah.
When you provide notice of those changes, you said you publish them. Where are you publishing them?
Yeah, typically we put those on our website so that folks are able
What's
to.
the website?
Our website.
Yep.
Yep.
What is it?
That's, I don't know the address.
It's
Is
just
it
columbus.gov?
Columbus.gov and then go to BZS.
Perfect.
Yeah.
There's about 60 people behind you that are probably interested in knowing how to find updates to rules and regulations. That's why I'm asking this question.
Sure. Typically, people go to columbus.gov and then they navigate to our page.
Okay.
There may be a direct website address, but
Awesome.
typically people go to columbus.gov.
Awesome. When we, I'm going to go back to the PEI inspections, so the every 3-year preventive inspections. What does it look like if you are doing a 3-year PEI inspection and you identify critical issues that need to be addressed? Is that property immediately moved onto kind of the conditional registration process? Can you talk about
Sure.
then what that looks like and what is the plan for remediation if you are doing that 3-year inspection and you find that there are issues that need to be addressed?
Sure. No, the property would not immediately be moved to conditional registration. The conditional registration is sort of a separate, I mentioned the 6 triggers that are outlined there that would trigger conditional registration. The preventive education inspection really would be, as I said, just merely referred to the relevant investigatory agency. So, right now, typically speaking, when you're dealing with properties, you have code enforcement, you would have fire, you would have the building section, and you would maybe have the health department. So let's say during that inspection, we found anything that would lead us to believe there might be a code violation of one of those sections, the housing code, the health code, the fire code, or the building code. That would be referred out to the relevant enforcement team. A couple of those belong to me as well. A couple of them don't. So it just depends on what we find as a part of the violation. Think of it like a 311 call or anything else that comes in that we use to respond to. And so when we go out and do that investigation, I think what I just want to clarify is we're not going to have a clipboard of blank orders and just start writing orders for people. Here's your inspection and here are 10 orders of things for you to correct. That is not how this inspection will work. The inspection is designed, that's why we call it a preventative education inspection. It's really designed to come alongside the owner to rectify problems that we see proactively, so they don't end up on someone's inspection list to come back out on. But if we find something serious, we also want to be clear that we're not just going to ignore that.
Right.
We're going to refer that out to the appropriate agency to follow up.
Perfect, thank you. In the changes for inspections relative to the 3-year preventive education inspections, you said there's an opportunity for self-attestation for properties without code violations. What does that self-attestation look like
So there will be a form that they would have to do an attestation on, a certification form that they would be, essentially saying that they've, to the best of their knowledge. I know we've gotten a lot of feedback in recent months on, well, how do I know if there's any code violations on my property? And we've added language that includes, to the best of my information, to the best of my knowledge. We're not going to, ask owners of a property to instantly become, a investigatory code specialist. We're basically focused on, you're not aware of any outstanding orders, you're not aware of any major critical system flaws, any failures in your property, that type of thing, to the best of your knowledge. We're not, again, I think Councilmember said, we've really struggled to make sure that this is not legislation that turns into a gotcha. That's not what we're trying to do here. We're really trying to come alongside owners to and protect tenants from really conditions that we think need to be rectified.
there are oftentimes developments or properties that have to go through a state inspection or a HUD inspection of their physical conditions? Would providing you the results of those inspections also work to fulfill the self-attestation requirement?
Yes, we have said in the code summary and in the legislation that, on that annual basis, if you happen to be a complex that has, formal inspections done by third parties, that we would get copies of those as well.
Great. And then this might be a question better suited for Deputy Director Jones. Oftentimes, we hear from tenants who get kind of complaint exhaustion when they feel like they're not receiving responses from their landlords timely. And so they get sick of complaining not only to their landlord, but also to the city. So there may or may not be a complaint record of code violations or potential code violations. Is there a way to notify a community that a preventive educational inspection is getting ready to happen, and that could be an opportunity for you to request an interior inspection if you feel like you've got issues that haven't been addressed by the landlord?
So I think that you have provided one example of the many ways that we see a collaboration opportunity. I think ultimately the goal is that there be an element of the registration process that is forward-facing and that the public can access. So I would anticipate that there would be a place where you could see what properties, depending on the timeline of registration, are due for their 3-year inspection. We would hope that we would also have the opportunity to go out if we are receiving complaints, or as the Division of Housing Stability is able to make a more robust community engagement process and have dialogues with neighbors and tenants, an opportunity to maybe flag for BZS and others as they are going out to conduct these. Hey, this is what we're hearing, this is what we're seeing. Again, as the director has alluded to, the idea here is that we are just verifying that you are already in compliance, that what you are attesting to is annually is true. And to have another opportunity to engage with individuals who, to your point, may have fatigue or may not even know the right place to engage. And understand their obligation as well, if there is one, if it's an issue that perhaps is more complex than just simply the landlord can't or won't fix it. What other resources can we bring that are not the obligation of code enforcement or others to help manage that relationship as well?
Great, thank you. Final question, I promise, at least for this time. Director Messer, do you anticipate that this registration opportunity really opens the door for earlier conversations with property owners and a real opportunity to, instead of waiting until you get hit with 16 or 17 code violations that you have to fix between 15 and 30 days, that you're having that time to engage with the department, understanding what the conditions of your property are, and really working with the department to get into compliance?
Absolutely, Councilmember. I think that's an important component of this proposal, and why we added the preventive education inspection is to really try to engage with and interact with our owners and our property, folks who are responsible for our properties out there, to try to come alongside. Not only that, but it's mentioned in the legislation that part of the fees are also allowed to be used for trying to remediate and trying to solve issues that we have out in the community, possibly in emergency situations or egregious situations. And so a big component of this is trying to improve our properties and make things better in the city. So absolutely, I think that collaborative approach is going to be something that we're hopeful about coming out of this. And I just want to add real quickly, I know you asked me about the legal process, and I still don't know all the details, but in addition to publishing our rules and regs on the website, we're also required to publish those in the city bulletin. And so there's a variety of formal things that we have to do. I apologize for not knowing the timelines and the details, but certainly any rules and regs that we do are published and accessible, and folks will be able to see those.
Awesome. I anticipate the website is probably a little more accessible than the city bulletin.
I agree.
It's a great read if you want to read the city bulletin. Thank you, Housing Chair Ross. Customer Watch.
So one, just on that communications piece and proactively communicating, I know we're still figuring out what that plan looks like. I would think the easiest thing, especially if we are going to change rules and regulations, is to email those who have signed up to the registry. So hopefully that is option number one, and we don't just put things on the website and assume folks will find it. So, but wanted to ask, kind of piggyback on Council Member Ross's question around tenants and tenants saying, "Hey, come on into my property." I assume maybe not in this legislation, but other parts of city code, protections for that tenant from potential retaliation from the property owners if they felt like the property owner is now targeting them because they chose to speak up and point to different issues that they were dealing with.
If your question is, are tenants already protected from that type of retaliatory behavior? The answer is yes. Not as a part of this code, but separately from this code. Our typical, tenant protections include protection from retaliatory action for folks calling 311 or reporting code violations.
Appreciate it, thank you. I mean, my other point, which I think you and I have discussed in terms of information being collected, kind of speaks to this review kind of on a maybe biannually or however we kind of finalize that in terms of what data is actually necessary for the city to continue to protect residents. You know, I've spoke many of times about having information for us to make further policy decisions. I understand at this time it is about let's set up the registry, let's have something that works, that can actually accomplish its job before we start doing additional things. But hopefully the departments feel like that can be a useful tool in the future. Would you agree to that?
Yes, council member, we've spoken about that, and there are several, informational tools that could be helpful as a part of this registry. Things that you just mentioned. One, just having the registry gives us a vehicle of communication to our property owners around the city and our rental folks. So there's going to be an opportunity for us to visit what type of information, even if some of that information is voluntary. I know folks have seen us refer to average rent, for example, as something we might be asking for. But whenever we've identified that, we've labeled that as optional, voluntary. There may be some other information that we want to ask for that's informational and voluntary, but really could help the city make policy decisions and policy questions in the future. And so this means is going to exist once we establish the registry to possibly gather information and tools to help us in other decisions.
Thank you, appreciate that, and appreciate all of you for kind of working through this and kind of providing an overview of the changes that have been made. I think the concerns we always hear from industry, residents, everyone is like, there's never an opportunity to help improve legislation. I think having multiple hearings kind of shows us making the sausage, as Councilmember Bankson indicated at the beginning of the meeting. So appreciate your willingness to kind of go back and forth to make this the best possible policy to support the needs of the city of Columbus.
Thank you, Councilmember.
Chair, I'm sorry.
Go ahead.
I'm going to get so much better at this, I promise. This last question.
Just don't say that.
All right. I'm going to try to get better and better at this. I do see something that says conditional registration may be implicated when complexes are declared to be a public nuisance by the department. In the event that the department has not declared the property to be a public nuisance, but the environmental court has declared the property to be a public nuisance, and there are prior kind of court cases on record with regard to this, if there is an open court case where the property has already been declared to be a public nuisance by the environmental court, is that also something that the department will consider in determining whether or not a property should be on this conditional?
Certainly, we can look at whether the language was intended to just say the department, or whether it's just in general that it's been declared a public nuisance by, a different agency. But generally speaking, if the court is going to declare something a public nuisance, we've probably already requested that or done so as well. But I get your point, and we'll take a look at that language.
And you're doing just fine, Councilmember Ross. This is not Congress, okay? We don't have like set standard meetings. This is not gotcha, As you can see, this is why I say I don't play a lawyer. She asked very lawyerly questions over there. So with that, Councilmember, any questions or comments from you? Okay, thank you. We will move into public comment. As with most of my hearings and traditions, we do keep track of what's happening on social media. So, Director, one question did come up, and I think you alluded to it, but I think we can just re-emphasize it. The question was, what can really be determined from an exterior inspection?
So I think when we're talking about if we're talking about the preventative education inspection, I don't want to insinuate that it's merely an exterior inspection. There may be some smaller rental units, say a single-family home or a duplex, where there really aren't any shared systems to look at, and basically it is an exterior inspection unless we get permission from the residents to do a safety inspection on the interior units. So I would submit that not as much can be determined from an exterior inspection, but generally speaking, just speaking from experience with thousands of properties around the city and over a decade of tenure, that it's very unusual to have a pristine exterior and a interior that would cause us significant distress. And so, you'd be surprised at what we can tell from an exterior inspection in terms of reflecting on the condition of the property. That being said, our primary effort of this preventative education inspection is going to be around really looking at common areas, shared critical systems like heating and cooling and water systems that serve apartment complexes and larger complexes, egress, retention ponds, all the things that aren't necessarily inside of a specific unit. And I would submit that those things can often be indicative of, the condition of the property overall.
Thank you for that, Director. Like I said, we'll move into public comment. Just wanted to acknowledge on the record that as of yesterday's 5 p.m. deadline, we did receive 3 pieces of written testimony, and those have been shared with all offices from Greg Lawson with the Buckeye Institute, Sarah Holskulter, and Sarah Dreyer. And with that, we will move into our public speakers. And so first up, we have 10 this evening. First up, we have Dimitri Hatzenfortinos. I swear I'm going to get it right one of these days, Dimitri. Followed by Steve Gladden. Welcome back to council. 3 minutes, and I think you know the deal.
Thank you, Councilmember Bankston, members of council. I appreciate the opportunity, and I have appreciated the opportunity to meet with you, Councilmember, and your staff to talk about this legislation over the last 90 days or so. And I think that the interactions have been positive to some extent. I represent about 100,000 multifamily operators in Columbus, along with the Columbus Apartment Association. Unfortunately, I'm here today to tell you that we will legally challenge this legislation as it currently stands, although we haven't seen the legislation yet, so it's a little premature to say that, but we're getting very close to, I think, a working product, and if this is the working product that we see in the code, we have no choice but to challenge it. And the reason we're going to challenge it are the reasons are these. As the director has said, this legislation is really intended to target 0.5% of bad actors in the city. And so we already have things in place to target those bad actors. It's nice that Attorney Dunbar is here because that's what he does most of the time, and I interact with him in that capacity, and he does a very good job of that. But we also already have a registry that is required by the state, and 90% of what you're asking for is duplicative. And the state statute clearly preempts your ability to ask for the same information that's already provided. And since the last time I spoke here, it became very evident to me that neither the administration nor council really looks at the auditor's information and determines who has registered and then uses it to actually find people. And so if we're not using the information that we already have, and about 60% of the people, the units in Columbus are registered, then it really makes no sense to create a second registry when we already have one. And that would be the first basis for us challenging this legislation, because you can't make us register twice. State law already makes us register. Second reason is that the fee that you're asking to be paid is a tax. There really has never been provided a budget or any useful information about where that money's going to go and how it's going to be used. There have been some things that have been alluded to, but ultimately, if the administration wants to do an exterior inspection of apartment complexes, they can just drive around. They don't need legislation for that. They don't need money for that. They're already there. Ultimately, anytime they inspect for code purposes, they can inspect the exteriors. They do that all the time practically, so that's duplicative as well. And it's difficult for the industry to understand how a fee is charged without a budget, particularly if it's only going to be used for this purpose. And we've asked for a budget through public records requests, and specifically to the director, we've been promised that, we haven't been given it. So that would be a second reason. The third reason is that you're really burdening the good actors to the exclusion of the bad actors. So the good actors are going to register. The good actors are going to participate. The good actors are going to pay. It is likely that the bad actors won't do that. And so the people that don't register, you're going to have to go collect fees from administratively and civilly that you're going to charge according to this legislation. And then you're going to turn around and try to find them to get inspections done and probably sue them for nuisance because they're not doing their job. And so all of the good actors that I represent are then being penalized for what the bad actors do. I'll just conclude real fast and just say, what I would suggest as an alternative to this legislation is to focus on the conditional registration and create a registry for those people, for those actors. The people that have 10 code violations per 100 that aren't complied with, the people that are a public nuisance. Get those people on a list and get them to register and get them to be inspected annually and get them to be more compliant and continue to work with those properties. Because a lot of times when we're in environmental court, we get through our agreed entry of compliance and then we forget about them and they're right back there in 10 minutes. So we focus on that 0.5% more heavily, and if they need to be charged for that, then that makes more sense to the industry. We also secondarily use the registry that we already have. So if you're going to pass legislation, say they can register with the auditor or with the city, and then if they're not registered, there's a penalty for that, rather than they have to register twice. So we would say conditional registration is the focus for inspections, and registration can be done at the auditor or at the city. It's curated and it's both are used because both are there. Compliance with one is compliance with the other. And then if there's an administrative cost burden to the city for that information, you can proceed to add to it if necessary down the road with regulation or with new legislation. So that's what we would propose instead. Thank you, and I'd take any questions if anyone has any.
Thank you, Dimitri, for your testimony. And I will say thank you again for leaning into this process. As I said, that we wanted to be transparent and work with you, and I think you have been at the table, and I hope that through this process you have seen that we've taken it serious, and I think made significant revisions to it, quite frankly, I think against some of the other advocacy that we have seen. So
Understood.
Thank you again, and Steve Dunbar is there, so I guess he'll see you in court. There you go.
All right, sounds good. Thank you all very much.
Thank you. Oh, I'm sorry. Dimitri,
Not
you
a
have
question.
from Mr.
I'll
Councilman
just
White.
note,
Sorry.
it sounded like we need to ask more information that's specific to Columbus. So I appreciate you mentioning that.
And after Mr. Gladman, we will have Cynthia Flattery.
Chairman Banks, members of council, my name is Steve Gladman. I live at 1300 Northwest Boulevard in Council District 7. I'm representing the Columbus Apartment Association today. I've made several comments in writing, and we met several times, and I appreciate the city, council staff, and administrative staff. I really just want to touch on 3 points. I'll probably have more detailed comments when it's in ordinance form. And those 3 comments really just center on conditional registration, preventative education inspection, and then the fee. The director's done a good job, I think, of quantifying there's 0.5% or 1% of the properties that are really a problem. And the idea of focusing on those problem properties, I think, has tremendous merit. We're supportive of that. We think it's efficient, effective, and equitable. The changes from the last draft of the proposal, I think, capture our biggest concern, which was not just a raw count, but non-compliance. So I think that is very much strength in that section and is a good rewrite. the preventative education inspection really pivots away from focusing on 1%, and now you're going back to having the entire population, the other 99%, have an administrative cost and administrative burden of reporting. And I understand the purpose of that, but as I read this, many of the items that are suggested under the preventative education inspection, and when we met with Director Messer in the past, things like boilers were mentioned, fire code, those are already covered. The boilers are inspected by the state on a regular schedule. The fire department can go in at any time and look at fire safety, look at egress, look at whether the fire extinguishers are current, if the lighting is proper. So a lot of this is already there. The city could do this anytime they want. They don't have to wait every 3 years to do it. And they don't necessarily have to charge the $15 per unit fee. As you heard earlier, we don't know what the $15, we don't know what the revenue projection is. We don't know the expense projection of those. So it's hard for us to say that that's in any way an equitable fee. We know what other cities charges, and it's from $1 to several dollars. So we look forward to having more information, more specific information about that. And again, would encourage the focus of this legislation to be on that 1% or less and have strong compliance and enforcement in that area, and not so much burden the entire population. I was talking about properties that would be 1 or 2 years old, having a proactive inspection and with a $15 per unit fee. Thank you.
Thank you again, Mr. Glavin, and appreciate you calling out those points and some things that we have made, and appreciate you leaning into the process as well. So thank you.
Thank you.
Next, we have Ms. Cynthia. I'm sorry, were there any questions or comments from? Okay. So Ms. Cynthia Flattery, followed by Jerry O'Neill. Good to see you again. Welcome back to council.
Councilman Bankston and members of City Council, my name is Cindy Flaherty, and I'm here representing BREAD, an organization of more than 40 religious congregations in Central Ohio. I'm currently serving as BREAD's vice president, and I'm a member of the St. Josephine Bakita Parish in North Columbus. We appreciate this opportunity to comment on the most recent draft proposal to create a City of Columbus rental registry. In the interest of time, I'll jump right to the point. The current complaint-based system of code enforcement is not adequate to address the issues of today's housing market. Research shows that to protect renters and to hold irresponsible landlords accountable, you must also have regular inspections by the city. The most recent draft proposal for the rental registry would put Columbus on the right path by instituting regular health and safety, education inspections in common areas. The city will identify many problems by the worst landlords. When the problems are found, they will be referred to the appropriate regulatory division for further action. We support the proposal and commend City Council for working through the complex legal issues that must be considered. At the same time, we think that the legislation could be even stronger, and I'll address these points in order. In the information section, rather than giving owners the option to report the average rent, we think the city should ask for a range of rents. This will provide more granular data that will be useful for the city and the public to track rent and affordability. The legislation should also clarify that the affirmation must be submitted at the time of registration. Under preventative education inspections, we recommend establishing a publicly available tracking system with timeframes and referrals for follow-up action by the appropriate agency. The preventative inspection should include infestation and mold. The legislation should address how inspections will occur for properties that have no common areas, such as duplexes and single-family homes. Under conditional registration, the threshold for properties with more than 100 units should be set at 6 or more units with violations in the last 12 months, rather than 10. Otherwise, there's a significant drop in the standard of properties that are just over 100 units. And under enforcement, it's unclear whether there will be any changes to the existing structure of fines for noncompliance with codes, including escalation for continued noncompliance. We hope this will be addressed in the final draft. In summary, we believe that the most recent draft proposal is strong, but it could be made even stronger with the addition of our suggestions. And we thank you for the opportunity to speak in support of the rental registry.
Thank you again, Cindy, and thanks, Brett, as well, for all your advocacy in this space. And as you said, I think, as I said from the beginning, there were going to be things that none of us got all that we wanted, but I will say that that is why we're putting in this, I think, review period, so that every few years that we are looking at this, getting to a place where this is up and running, I think we can continue to have those conversations. And so thank you for your advocacy, and look forward to continuing working with you. Next, we have Mr. Jerry O'Neill, followed by John Myers.
Council members, my name is Jerry O'Neill. I'm a third-generation real estate broker and property manager. We've been in business for 105 years here in the city of Columbus. We currently manage for over 231 small landlords, over 600 doors. In New Philadelphia, Ohio, Judge Elizabeth Lee Tamakos has ruled that Yurksville, Ohio's landlord registration fee is illegal and an unconstitutional tax. Taxes collected and not used for the betterment of the taxpayers that paid them are unconstitutional. Landlords are now, they won that case, and the landlords are now currently suing the city of Yurksville to refund all the monies that were paid. So that's already case law. From the Buckeye Institute, an independent research and educational institution, a think tank, whose mission is to advance free market public policy in the United States, I quote, "The proposed ordinance will be more harmful than beneficial. It will raise housing costs for Columbus renters, particularly those least able to afford them, without delivering any meaningful benefits that cannot already be achieved. The goal of improving and housing conditions and safety is laudable and understandable, but the proposed rental registry's design is flawed and expensive. It mandates annual registration fees, inspections, and administrative burdens that will increase rent prices and negatively affect renters downstream." So this is actually eliminating affordable housing in Columbus, which I believe is a goal of this council, is to increase affordable housing in Columbus. So adding costs is the opposite of what should be happening. IREM, the Institute of Real Estate Management, NARPM, the National Association of Residential Property Managers, the Columbus and Ohio Apartment Associations, COIN, the Central Ohio Investors Network, all oppose this rental registry. Doesn't that tell you something when everyone across the board is opposed to it? Rather than creating a costly new municipal registry that duplicates state requirements and adds additional compliance layers, the Columbus City Council should strengthen enforcement of the existing state-mandated county registration system and ask the General Assembly to increase penalties for non-compliance. A higher, more consistent penalty for failing to register at the county local rental registry would provide an effective deterrent. Importantly, it would not target honest property owners and would not risk needlessly raising rents for lower income residents. So I oppose this legislation.
Thank you, Mr. O'Neill. Any questions for Mr. O'Neill? Thank you, Mr. O'Neill, for your testimony, and also thank you for being a housing provider in our community. Yeah.
Thank you.
Next was Mr. John Myers, followed by Aaron Lance. Mr. Meyer, welcome to council. You have 3 minutes. The floor is yours.
Understood. Members of council, my name is John Myers. I've been a licensed realtor in Columbus for over 40 years and have served as a past president of Columbus Realtors. I'm the broker owner of a property management company. On the rental property management side of our business, we manage nearly 600 units in the Columbus area. And 90% of those, over 90% of those are residential. Our clients are small investors who may own one or a handful of properties, like a house, a four-family, that type of thing. Basically, your mom and pop investors are who our clients are. So I'm speaking for them as well as for myself. Let's be honest about what this is. A sweeping new regulatory mandate imposed on every rental property owner in Columbus, regardless of whether they've ever had a code violation, failed inspection, all of that. This is not targeted enforcement. It is a collective punishment. By your own numbers that we heard today, the problem is only with 0.5%. Not, the other 99.5 are not the problem, yet they're going to be affected negatively by this. Columbus does not have a rental registry problem. It has an enforcement problem. If there are bad actors, enforce the laws already on the books. But don't build an entirely new bureaucracy that treats responsible small landlords like they are presumed to be guilty. The ordinance adds annual reporting requirements, compliance risk, and new fees. In a housing market already strained by rising costs, those expenses will not be absorbed by the landlords. They will be passed on to renters. Every new regulatory layer becomes another line item in the cost of housing. And let's talk about the consequences. The people most affected by this will not be the large firms who already have people in place to handle this unnecessary burden. The people most affected will be local independent property owners, the family that owns a duplex, a retiree that owns a four-family. When the regulations pile up, they sell. And when they sell to larger institutional investors. If council's goal is affordability, local ownership, neighborhood stability, this policy moves us in the opposite direction. Thank you.
Thank you, Mr. Meyer, and also thank you for your service to the community as past president and for being a housing provider. Next, we have Aaron Lance, followed by Brian Bainbridge. And Aaron, I'm going to listen intently, but I have to go to the restroom. So.
Sorry, I didn't get what he said. Do I have to wait?
No worries. Chair Bankston had to run to the restroom.
No, I can't see. I'm legally blind, so I can't see anything.
No worries. Can you hear me?
I can hear you.
Awesome.
Yes.
Chair Bankston had to run to the restroom.
Okay.
You can either wait for him to return or you can provide your testimony in his absence. You still have Councilmember Ross and Councilmember Weish.
I'll wait.
Okay.
I don't mind.
Okay, sir. Chair Bankston is back.
Thank you. Hope you felt better, Banks.
Thank you. Thank
All
you,
right.
everyone.
Yeah, well, my name's Darren Lance, of course, and I am a tenant. I have an apartment. That's my home, and my landlord is great. They fix things right away. But what I want to talk about is I have friends who are not in the position that I am in. They have, runs the gamut from leaking roofs to leaking windows to heating not working. For example, my nephew, he actually has been living for the past 3 years, and his heat never gets above 54, but it runs continuously and hard to keep at 54. So he's paying $400 a month. But needless to say, I'm just saying there's protections are out there, and some people are nervous. Some of my friends are first-generation immigrants, and they are fearful to reach out and get the additional help beyond they think they pay their rent every month, and they should get their issues addressed. But they can't, or they don't know how to. So I think it was a little disingenuous what I hear earlier about paying $15 a month, how that will hurt the tenants. No, and it won't even hurt them. But what it will do is give them a home with heat without, and have them that ability. Their rent is already going up $50 a month. They typically, is what they're saying. So $15, if they want to add it, which would be what, $2 a month at most to their monthly rent, I don't think that would be an issue. And also, I think maybe 2 violations is way too many on a landlord. So I just want to make that note. So I'm sure mine has 0 violations because they're on it. So I also, it is a right, it's a human right for everybody to have a home, and a home with heat. And I enjoy that home. I think everybody else does. And when you own your own home and you pay a contractor to come in to fix your heat, you expect it to get done. So that's all I'm saying is people pay for this house or this apartment, and they should have that right to have heat or not have a leaking faucet. That's it. Thank you.
Thank you, Mr. Lance, and also thank you for allowing me to go to the restroom. And just to put a finer point on that, at $15, that is $1.25 per month, and is 4 cents per day in a year. With that, Brian Bainbridge is next, followed by Sarah Dreyer.
Good evening, Councilmember Bankston and members of council. My name is Brian Bainbridge. I'm a 17-year licensed real estate professional serving buyers and sellers and property owners and tenants throughout the city of Columbus. I appreciate the opportunity to speak today. It's been an honor here. Everyone in this room agrees that to provide safe, well-maintained housing is a goal we all share. Realtors especially, and I know landlords too, we work daily to provide responsible housing and to take pride in maintaining the quality and serving tenants professionally. I'm also a landlord. I have 14 properties, and as a community-focused agent, Council Member Day Alkire knows me personally, and a real estate agent, I aim to provide a nicer quality housing for all my tenants. Plainly put, the current registry is a regulatory scheme as it currently sits. As currently structured, it's creating new layers of regulation that risk harming housing supply, affordability, and small property owners without clearly demonstrating measurable safety gains. The proposal imposes a mandatory annual registration requirement on all residential properties. This is not just a targeted enforcement tool, it is a blanket regulatory expansion, creating double enforcement with the Columbus Code Department, and therefore screams big government inefficiency. The overwhelming, as said before, the overwhelming majority of rental providers in Columbus already comply with the existing safety, building, and housing codes. This ordinance presumes systematic non-compliance and imposes new administrative burdens regardless of the performance history. Second, the excessive costs. This is not just about the $15, as said, along with the Gestapo-style inspections, will not only be absorbed by the property owners, but in today's tight housing market, the regulatory costs will be often passed through the form of higher rents. And modest annual fees multiplied by across thousands of units can materially affect the housing affordability. I mean, quite honestly, go off script here. My rentals, I make very little money each month as is. There's a handful of them. You know, I'm in it for the equity gain. I'm not making a ton of money. So that's, you know, for us small people, it hurts. I would say one of my last points here is that this legislation hurts small business. For those that, I know there's an exemption with those who fall smaller than 10 units. It also creates a regulatory framework that disproportionately impacts small to mid-sized providers like myself. I'm doing this for retirement for me and my wife. Fourth, the compliant property owners will bear the administrative costs, and the bad actors will not. Listen, you guys your hearts are in the right place. I just don't think this legislative initiative is the way to go about doing it. So, do you have any questions? Thank you for your time.
Absolutely, and thank you, Mr. Bainbridge, for your testimony today, and also again for being a housing provider in our community.
Thank you.
Next, we have Ms. Sarah Dreyer, followed by Deb Krantz.
Good evening to the council, and I want to applaud you, Council Member Bankston, for your leadership on this rental registry. I moved into my current residence in 2022 because I thought it was a safe place to live for my son and my two nieces who I've adopted. In 2021, my sister, their mother, was shot and killed by her husband, their father. At the time, my nieces were out of town. I adopted them and brought them to Columbus. I was living on the Near East Side, furthering my education. And the gunshots that were happening in the neighborhood were very triggering, and I did not want the children to be even further traumatized. So I thought, where could I live where it was a nicer part of the town, and I moved to Clintonville. The children set up school there. They really love it at Indianola. And my neighbors were great. The children could play outside without fear. We live right by Glen Echo. It's so therapeutic. The current owner of that home was a person who's not involved in a lot of real estate. I heard a lot about small rental, the low number. So this testimony is about someone who only owns one, I think maybe two properties. It was an older woman, and she did great the first 2 years. And after the first 2 years, she passed away and gave it to her son, who's, I am 40, I think he's in his 50s, so not too much older than me. At that time, things changed drastically. He changed property managers to a cheaper company who was very ineffective and very unattentive. The maintenance men that wouldn't come back because they realized they weren't going to get paid. Consistently, he was not approving the funds needed to maintain very essential repairs in the home. Quickly, my illusion of living in a nicer neighborhood and it being safer was, that dream became a nightmare because of this landlord. Eventually, I called 311 and multiple code violations were found against him. And by multiple, I mean more than 3. I think it's about 5. I have to look back over the course of the last 14 months. It's been numerous times, including piping, black mold, structures outside that were completely unsafe, that it should have never been on the home in the first place when I moved into it. And that is why I say, I believe that you should move forward with this because it could have possibly prevented me from going through what I'm going through now. I'm actually working with 311. There's a tenant protection clause set up by Shayla Favors. That is the only thing that is helping me seek seek justice for them retaliating against me. I just believe that if this ordinance were there in place ahead of time, that this would not have happened. And I would hope and pray that this ordinance put in place will prevent others from going through the hell that I had to go through. Thank you.
Mr. Dreyer, let me just say
Yes.
thank you for being vulnerable and giving us your personal story.
Yes,
And sorry that is your experience.
yes,
This piece of legislation won't be the silver bullet, but I think it's the package
yes.
of everything that has been done under Councilmember Shayla Favor, now under Councilmember Ross, that
Yes.
we want to continue to get this right. It's not about, I think, penalizing or being burdensome, but it is these types of stories that we want to prevent. So thank you
Yeah.
again for sharing your story with us, and I appreciate it.
Thank you, Bob.
Next is Deb Krantz, and then finally rounding us out will be Miss Sarah Holskalter, which I'm probably butchering, and I apologize. Welcome, Council.
Thank you, Councilmember Bankston, other council members. I'm Deb Krantz. I am a rental property provider in Central Ohio and Columbus specifically. I'm also a private lender to other rental housing providers in Columbus and elsewhere in addition. I thank you for another opportunity to provide comments on the proposed legislation. Last time I was here, Councilmember Bankston, you asked me, why did I think housing providers would sell their Columbus portfolios if the rental registry was implemented? And at the time, it was a $20 chump change. Now it's $15. Well, what's a couple more bucks and an inspection, the cost of an inspection? And I thought you were joking, to be honest, but you had just heard hours of comments in opposition to the proposed legislation, but you were serious. So I came prepared with a couple of things that might help you understand what rental housing providers are living in real time. So I wanted to talk about maintenance for a second. Generally speaking, my own experience as a rental housing provider, we generally do 2 preventive maintenance calls each year, and then we budget for another unexpected expense. I'm going to use for my example a backed up drain because that happens. So I wanted to give you a sense that basic service calls, I look back to 2020, those are about $75 for each one. In 2025, we're at about $130. That's about a 75% increase. Snaking a main drain in 2020 was $185. In 2025, it's about $280. It's a 51% increase. So overall, it's about $17 a month for the maintenance that we generally provide. Water and sewer, and I'm quoting from the Columbus Water Sewer Utility, whatever you guys rebranded that. Quote, overall average increase for 2026 will be about 11.72%. For a 3-person household, which is pretty common in my case, that's about a $27 a month increase over last year. Property insurance, average increase of 7.3%. For 2026, it's about $7 a month. Property tax, I think I had mentioned last time I was here, over my portfolio, my increase has been between, the range was 175% to 325%. Overall, our average increase is about 275% across our portfolio. It's $93 a month. All of that is $144 a month increase. That's about a 10% increase if we use $1,500 a month for average rent. That's about as much as any tenant can tolerate for a rental increase, and I would agree, it's a lot. And my point is, it doesn't take much more cost or uncertainty about legislation for investors to go elsewhere. It invites the housing providers that communities like less, who buy from those who are better informed about local business conditions. Those who are selling their Columbus properties will sell at market rates, as we should, but deep-pocketed investors, often from out of the area, can better afford those rates. And I think it's been mentioned, I attended the Ohio Supreme Court on January 8th, and I heard the oral arguments on rental inspections without warrants being their no probable cause. I do think that there's going to be a constitutional question here, and I invite the opportunity to defend that. This legislation assumes that all housing providers are guilty of something until the city decides otherwise. I believe the expense of defending good maintenance is time and money wasted that could have gone to creating more quality housing. I thank you again for your time.
Thank you, Ms. Cranston. Thank you for being a part of the process and coming back and testifying. I also just want to say thank you for being a responsible housing provider in our community. Last but not least, we have Ms. Sarah. Come on up. You're going to have to teach me how to say it. They didn't give me a phonetic spelling on here, so.
I'm short. Good evening, council members. My name is S. Holsketter. I use they, them pronouns. I'm still working on changing my
Holsketter.
identifiers.
I got it.
It's long, I get it. For 3 years, I ran a pilot project at the eviction court. I saw up to 200 people per day, and I have confirmed with the current eviction court social workers that the situation I described remains the same today. The threat of an eviction filing, even if it's baseless and will get thrown out as soon as it hits the court, is enough to cow a person into not following up on conditions and repairs. There is zero proof required of late payment or of any lease violation when a landlord goes to actually file an eviction. Retaliatory eviction filings will still show up on a tenant's record for the next 5 to 7 years, barring that tenant from at least 50% of the available rentals in the city should they want to move. This filing remains on Fabco and other credit reporting agencies' records, even if the landlord drops the case the next day, even if the tenant has the eviction filing removed from the public record, and even if the tenant wins the eviction case. More often than not, and by a wide margin, eviction court tenants with even severe conditions and habitability issues that I met had not pursued them with the city because they feared that their landlord would file an eviction in retaliation for their complaint. I have seen photos of truly deplorable conditions that tenants endured for months before being reported to the city. Mushrooms growing in somebody's living room, sewage up to somebody's knees, holes in the ceiling. Even the escrow process does not block a landlord from simultaneously filing an eviction and offers the tenant no protection from having that filing on their record. I recently attended a webinar run by Shelterforce, a national housing-focused publication, which focused on habitability issues. The links to the resources I mentioned were provided in the email I sent. They gave many examples of municipalities where proactive inspections have hugely impacted the quality of life tenants can expect, and they don't cost the city significantly more money. New Orleans is an example of how registries and permits can be used to neutralize bad slumlords and improve housing conditions while maintaining compliance with statewide laws similar to ours that prohibit rent control, interference with tenant-landlord relationships, and etc. For this reason, proactive inspections are a crucial, non-disposable component of the rental registry, especially all of the indicators that were proposed by BRED are, again, going towards that idea of proactive, tenant safety-focused components. A complaint-based system will not catch all the bad actors. Focusing on what we currently have will not catch all of the bad actors, and I would submit to you that it would cost less, that it will provide far less protection to renters. Sorry, I'll wrap up. It will provide far less protection to renters than a proactive system, and most renters, myself included, would rather pay $1.50 extra per month for the safety of knowing that when I call and am in deep distress, I'm going to get some sort of support. And that, I'd rather pay $1.50 per month knowing that it's not going to come down on me if my landlord needs to fix something. Thank you.
Thank you for your testimony and advocacy and everything that you're doing in the eviction court to help our residents. I really appreciate that. And I'm going to save you a little bit of money. It's $1.25 per month. That concludes all of our public speakers for this afternoon's hearing. Again, I want to thank everyone who came to give public testimony. My office will, again, take this feedback and continue to work with folks. And I will say, this isn't the end of a conversation. Continue to please reach out to my office because we want to continue to be engaged. As I said, that we will ensure that there's a review period and a look back period for this policy, because we want to continue to strengthen it and to evolve it to make sure that it meets our needs as a community. Again, please keep an eye out for additional information from my office regarding next steps, which will most likely involve official consideration by council by March. So we will have, of course, a first reading and then a second reading. So again, there will still be more time for dialogue and discussion. Before we wrap up, any closing comments from any of my colleagues? I also want to thank, she left and I was trying to get her before she left, but also she was here. I wanted to thank Jessica Klinger in Council President Harden's office. She's done a lot of work behind the scenes as well to get us to this point. As you know, Council President was the interim housing chair before Councilmember Ross, and so I just wanted to make sure I acknowledge Jessica and thanked her for all her work. Also want to again thank my team, Mr. Brown and Mr. Dorval, for all of their work as well, and continue to reach out to us, engage with us. With that, I will conclude this hearing. Have a great evening, everybody.